Nicaragua versus US. In July 1979, the government of President Somoza was replaced by a government installed by the Frente Sandinista de Liberación Nacional. Supporters of the former Somoza government and former members of the National Guard opposed the new government. The United States, initially supportive of the new government, changed its attitude when, according to the United States, it found that Nicaragua was providing logistical support and weapons to guerrillas in El Salvador. In April 1981, the U.S. stopped its aid to Nicaragua, and on September 1981, according to Nicaragua, the U.S. decided to plan and undertake activities directed against Nicaragua. The armed activities against the new government was carried mainly by Fuerza Democrática Nicaragüena, which opposed along the border with Honduras, and Alianza Revolucionaria Democrática, which operated along the border with Costa Rica. Initial United States support to these groups fighting against the Nicaraguan government, called Contras, was covered later. The U.S. officially called this support. Nicaragua also alleged that the U.S. is effectively in control of the Contras. The U.S. devised their strategy and directed their tactics, and that the Contras were paid for and directly controlled by the U.S. Nicaragua were carried out directly by the U.S. military with the aim to overthrow the government of Nicaragua. Attacks against Nicaragua included the mining of Nicaraguan ports and the other attacks on ports, oil installation, and naval base. The U.S. did not appear before the ICJ at the marriage stage, after refusing to accept the ICJ's jurisdiction to decide the case. Of the jurisdictional phase of the hearing, however, stated that it relied to decide on an inherent right of collective self-defense guaranteed in Article 51 of the UN Charter, when it provided, upon request, proportionate and appropriate assistance to Costa Rica, Honduras, and El Salvador in response to Nicaraguan acts of aggression against those countries. Issue: did the United States violates the customary international law obligation not to intervene in the affairs of another state when it trained, armed, equipped, and financed the Contra forces, or when it encouraged, supported, and aided the military and parliamentary activities against Nicaragua? The court held that the practice did not be in absolute conformity with the purported customary rule. Also, the court said that for a new rule to be formed, not only must the acts concerned amount to a settled practice, but they must be accompanied by the opinio juris necessitatis. Either the states taking such action on the other states in a position to react to it must behave so that their conduct is evidence of belief that this practice is rendered obligatory by the existence of a rule requiring it. The final case is Blackmer versus United States. Facts: Harry M. Blackmer, a citizen of the United States, resident in Paris, France, was adjudged guilty of contempt of the Supreme Court, District of Columbia, for failure to respond to subpoenas served upon him in France and requiring him to appear as a witness in behalf of the United States at the criminal trial in that court. The two subpoenas were issued for appearance at different times, and there were separate proceedings with respect to each. The two cases were heard together, and a fine of $30,000 with cause was imposed in each case to be satisfied out of the property of petitioner, which has been seized by order of the court. The two subpoenas were issued and served, and the proceeding to punish for contempt were taken under the provision of the Act of July 3, 1926, which provides that whenever the attendance at the trial of a criminal action of a witness abroad is a citizen of the United States or domiciled therein, as desired by the Attorney General or any assistant or district attorney acting under him, the judge of the court in which the action is pending may order a subpoena to issue to be addressed to a consul of the United States and to be served by him personally upon witness with a tender of traveling expenses. Petitioner argues that the statute and proceedings as being repugnant to the Constitution of the United States, especially the due process clause of the Fifth Amendment. Issue: may he be adjudged guilty of contempt of court? The court held yes. For U.S. processes properly served may bind U.S. citizens abroad. They may be required him to return to the U.S. and fail to do so may result in punishment.